Welcome to the September the 9th convening of the Baltimore City Board of Municipal and Zoning Appeals. A few ground rules before we get started. First, you'll note that there are a number of microphones that are arrayed around us up here, and those microphones are all very sensitive. They're not just for the purpose of amplification, but also for the purpose of recording these proceedings. Additionally, those of you who are sitting forward of the wall can, if you turn around and look behind you, you'll see that there are 3 video cameras mounted behind you, and there are 2 video cameras mounted behind us up here. These proceedings are being video recorded as well and broadcast on the city's public access channel. I bring both of these points up to say that to the extent that you have a cell phone, a pager, anything that makes any kind of audible electronic noise, anything that plays a ringtone, chime, what have you, we ask that at a minimum you turn that to a vibrate-only position, as cell phones, pagers, and whatever electronic gadgets you may have not only disturb the general conduct of the proceedings, but also the recording of the proceedings. Additionally, to the extent that you find it necessary to have a conversation with someone who's your neighbor, or maybe someone who's not quite close enough to be a neighbor, we ask that you please take that conversation out the double doors to your rear, as conversations in the gallery interrupt the general conduct of the proceedings as well as recording the proceedings. We will be voting at the end of the day. You're certainly more than welcome to stick around and enjoy this lovely, I guess, late summer, but more feels like early fall afternoon, and that would be quite understandable. If you so choose to do that, you can call into the zoning board office in the morning and find out how we ruled. If you take out pen and paper, I can give you the number for the zoning board office, and I'll read this number off a couple of times. That number is 410-396-4301. Again, the number is 410-396-4301. You will, however, need to wait until you receive the formal written outcome of your case that should be forthcoming in about 3 to 4 weeks. We certainly ask that you please not build in the city of Baltimore without first obtaining proper permits. If you've not already done so, if you're here in opposition to any case on our docket today, we ask that you please sign in on a sign-in sheet, which is being held up by Mr. Henry. Sign-in sheet allows us generally to know not only which cases have opposition, but also allow us to know who needs to receive those aforementioned written notices I just talked about. So if you're here in opposition to a case and you'd like to find out how we ruled in the case, or if the case gets postponed and you'd like to be notified as to when the case will be proceeding, we need to know who you are and where we can find you and where we can send you notice. So please sign in if you're here in opposition to any case. The procedure for when the cases are called: if you're the appellant or here on behalf of the appellant, you will come up and stand to my left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you sworn in, and we will first be hearing from the appellant, who will be given the opportunity to present their side of things, answer any questions from the board, tell us what the issues are and what it is that they're proposing. Once they're concluded, we'll then turn to the opposition, if any, who will be given a time to speak at that point and present their side of things. Finally, we're returning back to the appellant, who will be given the opportunity to respond to any points brought up by their opposition and to offer a closing statement. We won't be going back and forth, unnecessarily keeping everyone here into the evening. We will generally be calling cases in the order in which they appear on the docket after we first address some preliminary issues. First, we have a number of cases that are being postponed. These cases will not be heard today. So listen up and make sure that your case is not postponed. If it winds up being postponed, so long as you have signed in on the signing sheet, we'll be notified when the case will go forward, but these cases will not be going forward today. 2014-165, 3050 Liberty Heights Avenue, that case has been postponed. That case is being postponed until October the 7th. Next, 2014-307, 101 through 115 West 25th Street. That case has been postponed also until October 7th. 2014-308, 223 through 25 Park Avenue. That case has been postponed until October the 21st. I think we have one more. Yes, and another one, 2014-332, 714 through 16 North Fremont Avenue. That case has been postponed. It has not been reset as of yet, so you'll need to come back and find out when that case will be heard. Next are the cases which are on our consent agenda. These are cases where the zoning board staff has already reviewed the files and determined that we have sufficient information to approve these appeals. We'll call all of the consent cases together as a group. Once they're all read off and everyone is up here, we'll get you sworn in as a group. We'll go through each one in turn. You'll be given the opportunity then to add any more information that you would like to have added to the record. But if you are on the consent agenda, if the first person can come up and line up here, and then everyone else will line up down the dais behind them. 2014-297, 208 South Pulaski Street, Verizon Wireless, care of Jack Andrews. Next is 2014-220, 1118 through 20 South Charles Street, Ian Sokolowski. Mr. Andrews? Come on, line up right there. Next is 2014-247, 1000 through 1012 South Charles Street, Verizon Wireless, care of Julie McIntosh. Next, 2014-298, 113 Witherspoon Road, Carol and Mark Gould. 2014-299, 3600 Elm Street, Daniela Uselli. Next, 2014-300, 6201 Seaforth Street, Nathaniel Green. 2014-302, 4314 Springdale Avenue, Shanae Saunders. 2014-304, 3501 Brems Lane, Michelle Dewberry. 2014-310, 1008 West Cross Street, ACS Properties, care of Terry Blair. Tony Blair is the former Prime Minister of England. A bit of a step down. 2014-312, 901 and 907 Holland Street, Murtu Ted Tedeschi. 2014-316, 1118 through 20 South Charles Street. That's also Ian Sokolowski. 2014-317, 55 Marketplace, Verizon Wireless, care of Jack Andrews. 2014-320, 3801 through 07 Pall Mall Road, Michael Wallace. 2014-321, thanks. 2014-321, 3308 and 3310 Ridgewood Avenue, Nathaniel Green. Jumping back, 2014-315, 3607 Fleet Street and the south side of Fleet Street, 100 feet east of South Conkling Street, AV Associates, care of Nate Predel. 2014-324, 2031 through 33 West Baltimore Street, Ossie Tate. 2014-325, 6420 through 6506 Park Heights Avenue, James and Toya Cusack. 2014-327, no, not that one. 2014-331, 1713 East Pratt Street, Verizon Wireless, care of Ryan Deere. And 2014-333, 312 South Robinson Street, Chris Dotson. Okay. All right, if you all could raise your hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
All right, calling first case, 2014-297, 208 South Pulaski Street, Verizon Wireless, care of Jack Andrews. Mr. Andrews will also call this together with 2014-317, 55 Marketplace, which is also Verizon Wireless, care of Jack Andrews. You're Mr. Andrews?
Yes, sir.
All right, Mr. Andrews, as to case number 2014-297, 208 South Pulaski Street, we have that as an application to install a rooftop telecommunications facility consisting of 20 antennas with equipment onto a warehouse. Is that correct?
Yes, sir.
Okay. And Mr. French, what say you for the planning department?
Thank you. Martin French for the Baltimore City Planning Department. Planning Department recommends approval of this application, subject to these conditions. That the antennas and equipment must be painted to match the building to ensure they are visually unobtrusive. The antennas and related equipment will remain mounted as illustrated in the plans and elevations submitted to the Planning Department. And the applicant will adequately mitigate any adverse effect specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
All right, Mr. Andrews, are you amenable to those conditions stated by the planning department?
Yes, sir. The applicant has no objections.
Okay, and did you have anything further to add to the record?
No, sir.
Okay, zoning board staff having previously reviewed the application and determined there's sufficient information to approve your appeal. As to case number 2014-317, 55 Marketplace, we have that as an application to construct a new telecommunication facility onto the rooftop of a parking garage with lower level commercial uses. Is that correct?
Yes, sir. Just to clarify, they'll be mounted on the side of the parking garage, not necessarily on the roof.
Okay. All right, I'll make sure that that's changes made into the record. And Mr. French, anything for the planning board?
Yes, thank you. The department recommends approval of the appeal, subject to these conditions. The exposed antennas and related equipment must be painted to match the building to ensure that they are visually unobtrusive. The antennas and related equipment will remain mounted as illustrated in the plans and elevations to be submitted to and approved by planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you. And Mr. Andrews, is your applicant amenable to those conditions?
No objection, sir.
All right. Zoning board staff having previously reviewed the application and determined there's sufficient information to approve your appeal.
Thank you for your time.
Thank you.
Appreciate it.
Next case, 2014-220, 1118 through 20 South Charles Street. We'll call that together with appeal number 2014-316, which is also 1118 through 20 South Charles Street, both presented by Mr. Ian Sokolowski. Mr. Sokolowski, as to appeal number 220, we have that as an application to add outdoor table services as an accessory use to an existing first-floor restaurant and tavern use, including live entertainment and dancing, in the portion known as 1118 South Charles Street, store number 110. Is that correct?
That is correct.
Okay. And as to appeal number 316, we have that as a request to add outdoor table service as accessory to use, as accessory use to the existing first-floor restaurant in the portion known as 1118 South Charles Street, store number 101. Is that correct?
Yes, sir.
Okay. Mr. French for the planning department.
Thank you. With regard to the first application, case 2014-220, Planning Department recommends approval of the appeal, subject to these conditions. A minimum of 8 feet of the sidewalk must remain clear and unobstructed for pedestrian use. The capacity of the outdoor seating area will be not more than 3 tables and 12 patrons. The tables will be limited to those that can seat 4 patrons and are to be kept against the wall of the building. There will be no outdoor bar, outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by wait staff.
Okay.
Yes.
And Mr. Sokolowski, is your client amenable to those conditions stated by the planning department?
Yes.
Okay. And Mr. French,
With
as
regard to application 2014-316, Planning Department recommends approval of the appeal, subject to these conditions. A minimum of 8 feet of the sidewalk must remain clear and unobstructed for pedestrian use. The capacity of the outdoor seating area will be not more than 2 tables and 8 patrons. The tables will be limited to those that can seat 4 patrons and are to be kept against the wall of the building. There will be no outdoor bar, outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by waitstaff. Thank you.
Okay, and Mr. Sokolowski, is your client amenable to those conditions stated by the planning department?
Yes.
Okay. Sir, are you here on this case?
Peter Previs, I'm the attorney for the unit 110.
Okay. And Mr. Previs, did you have anything to add?
No, sir.
Okay. And Mr. Sokolowski, did you have anything further to add to the record?
Yes, sir.
All right. Zoning board staff, having previously reviewed your application, determined that there is sufficient information to approve your appeal. Thank you.
Thank you.
Thank you. Next case, 2014-247, 1000 through 1012 South Charles Street, Verizon Wireless, care of Julie McIntosh.
Yes, sir, Ryan Deere on the application.
All
I
right.
also have another case later at 3:31, if you want to call them again.
All right. Okay, I see that. 2014-331, 1713 East Pratt Street, also Verizon Wireless, care of Ryan Deere. All right, Mr. Deere, we have, as to appeal number 2014-247, we have that as an application to construct a new telecommunications facility onto the rooftop. Is that correct?
Correct.
All right, and Mr. French for the planning department?
Thank you. The Department of Planning recommends approval of this appeal, subject to these conditions. The exposed related equipment must be painted to match the building to ensure that it is visually unobtrusive. Panel antennas and related equipment will remain mounted as illustrated in the plans and elevations submitted to planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
Thank you. And Mr. Deere, is your client amenable to those conditions stated by the planning department?
Yes, sir.
Okay. Anything further to add?
No, sir.
All right. Zoning board staff, having previously reviewed your application, determined that there is sufficient information to approve your appeal. As to appeal number 2014-331, 1713 East Pratt Street, this is also Verizon Wireless, care of Ryan Deere. We have this as an application to install a additional new telecommunication facility consisting of 16 antennas with equipment onto rooftop of a restaurant. Is that correct?
Correct.
All right. Mr. French for the planning department?
Thank you. The Department of Planning recommends approval of the appeal, subject to these conditions. Any exposed antennas or related equipment must be painted to match the building to ensure that they are visually unobtrusive. Panel antennas and related equipment will remain mounted as illustrated in the plans and elevations submitted to and approved by planning, and the applicant will adequately mitigate any adverse effect as specified in the report of the Historical and Architectural Preservation Division of the Department of Planning in accordance with that report's recommendations. Thank you.
All right. Mr. Deere, is your client amenable to those conditions stated by the planning department?
Yes, sir.
All right. Zoning board staff, having previously reviewed the application, we determine there is sufficient information to approve your appeal. Thank you. Next up, 2014-298, 113 Witherspoon Road, Carol and Mark Gould.
Yes,
Okay, Ms. Gould, we have this as an application to construct a one-story side addition. Is that correct?
that's correct.
All right. Mr. French, anything for the planning department?
Planning Department has no comment on this application. Thank you.
Thank you. And Ms. Gould, did you have anything you'd like to add this supplement the record?
No,
Okay. Zoning board staff, having previously reviewed your application, we determine that there is sufficient information to approve your appeal. Thank you. Next up, 2014-299, 3600 Elm Avenue, Daniela Uselli.
I'm William Bauer on behalf of Daniela, who's in Italy right now, and this is her son Stefano Tonda, who's here before her, too.
Okay, Mr. Bauer, we have this as an application to add catering and outdoor table services as accessory to the existing bakery and restaurant use in the portion known as 900 West 36th Street.
Yes, sir.
All right. Mr. French for the planning department?
Thank you. Planning Department recommends approval of this appeal, subject to these conditions. A minimum of 7 feet of the sidewalk must remain clear and unobstructed for pedestrian use. The capacity of the outdoor seating area will be not more than 4 tables and 16 chairs. The tables will be limited to those that can seat 4 patrons and are to be kept against the wall of the building. There will be no outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by waitstaff. Thank you. That is an amendment of the formal memo which was given to the board earlier, because there was a question about the size of the area of the sidewalk that was going to be used for tables and seating. and the applicant has submitted a revised plan to the department indicating the capacity, and the department is agreeing with that.
Okay. All right, Mr. Bauer, is the applicant satisfied with the conditions stated by the planning department?
Yes, sir.
All right. Was there anything further you'd like to add to supplement the record?
We just have letter of support from the Hamden Community Council and the Hamden Village Merchant Association. If you'd like to have that for your records.
Sure. Oh, we do?
Awesome.
Okay. There
Thank you very
can
much.
have those. Anything further?
That's it.
All right. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Thank you, gentlemen. Thank you,
Thank you.
ladies. Thank you
Good
very
luck.
much. Take care.
Next up, 2014-300, 6201 Seaforth Street, Nathaniel Green. Afternoon, Mr. Green. We have this as an application to construct a one-story side addition onto a warehouse. Is that correct? All right. Mr. French, anything for the planning department?
The planning department recommends approval of this application. Thank you.
Thank you. And Mr. Green, anything further? All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thank you. You got another? Oh, that's what you do. 2014-321, 3308 and 3310 Ridgewood Avenue, also Nathaniel Green. Mr. Green, we have this as an application to consolidate lots and construct a one-story office addition for the existing contractor's shop and yard. Is that correct? That's correct. All right. Mr. French, anything from the planning department as this appeal?
Planning department has no comment on this application. Thank you.
All right. And Mr. Green, anything further? All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thank you. Take care. Next, 2014-302, 4314 Springdale Avenue, Shanae Saunders. Ms. Saunders, we have this as an application to construct a 6-foot-high fence in the backyard with a portion in the street side yard. Is that correct? All right. And Mr. French, anything from the planning department?
Planning department has no comment on this application. Thank you.
Thank you. Ms. Saunders, anything you'd like to add to supplement the record? No, sir. All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thank you. Next, 2014-304, 3501 Brems Lane, Michelle Dewberry. Afternoon. Ms. Dewberry, we have this as an application to use portion of the premises as a 37-child daycare center. Is that correct? Yes. All right. Mr. French, anything from the planning department?
The planning department recommends approval of this application. Thank you.
Thank you. And Ms. Dewberry, anything you'd like to offer to supplement the record? No. All right. Zoning board staff, having previously reviewed the application, we know that there is sufficient information to approve your appeal. Okay, thank you. Next case, 2014-310, 1008 West Cross Street, ACS Properties, care of Terry Blair. Afternoon. We have this as an application to use the premises for 2 dwelling units. Is that correct? Yes. All right. Mr. French, anything from the planning department?
Planning department has no objection to this application. Thank you.
Thank you. And Ms. Blair, anything you'd like to offer to supplement the record? All right. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal. Thank you. Next case, 2014-312, 901 and 907 Holland Street. Muretu Ted Tedesi. All right, Mr. Destiny, we have this as an application to expand the existing adult learning center, multi-purpose community center, located at 901 Holland Street by consolidating the lots and construct a 3-story rear addition onto and raise the roof of 907 Holland Street. Is that correct? All right. Mr. French, anything for the planning department?
Planning department recommends approval of this application, subject to the condition that the property and the adjoining property known as 901 Holland Street are consolidated before construction of the improvements relating to the change of use of the property. Thank you.
Thank you. And Mr. Tedesi, are you amenable to the conditions stated by the planning department?
Yes, sir. It's actually approved. The consolidation was already approved.
Great. Anything you'd like to offer to supplement the record?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal.
Thank you, Mr. Chairman.
Thank you. Good luck. Next case, 2014-315, 3607 Fleet Street and south side of Fleet Street, 100 feet east of South Conkling Street. AB Associates, care of Nate Pro. Mr. Prettle, we have this as an application to consolidate the lots and subdivide into 11 lots and construct 10 four-story attached single-family dwellings with rooftop decks accessed from the fourth floors and use the 11th lot for a private right-of-way. Is that correct?
Not exactly. Much of that was already approved in a previous appeal. This was
Okay.
just an amendment to expand the size of the proposed fourth floors for each house.
Okay. Do we have those drawings?
Yeah. This request came to the board in a letter requesting an amended resolution, and the board determined that it should go through the hearing process instead of doing it administratively. That's how it came to the board.
Gotcha.
The fourth floor additions previously were smaller, and now I think they're, what, 20 feet?
Yes, they expanded by approximately 193 square feet each. The
Okay.
subdivision has already been approved by the planning commission.
Okay.
So the only issue is the larger.
So the expansion of the fourth floor.
Right.
Okay. Let's correct the record there. And fourth floors as shown on drawings submitted. All right, Mr. French for the planning department.
Thank you. The Department of Planning has no objection to the appeal, as mentioned by the applicant. I note that approval of the subdivision was given by the Planning Commission on August the 7th, 2014. We also note that the FAR increase would be from approximately 2.6, which was a variance of 4%, up to 2.85 approximately. And therefore, this is not considered a significant increase in the size of the property's development. Thank you.
Okay. Mr. Prettle, anything further you'd like to add to something on the record?
No.
All right. The zoning board staff, having previously reviewed the application, determined that there's sufficient information to approve your appeal.
Great. Thank you.
Thank you. Next, 2014-320, 3801 through 07 Pall Mall Road, Michael Wallace. Good afternoon, Mr. Wallace. We have this as an application to construct a one-story side addition and use the premises as a 75-seat church with 6 off-street parking spaces. Is that correct?
That's correct.
All right. Mr. French, anything for the planning department?
Planning Department has no objection to this application. We note that the department staff has worked with the applicant to devise the plan that is in front of you today. Thank you.
And Mr. Wallace, anything further? No. Zoning board staff, having previously reviewed the application, we think that there is sufficient information to approve your appeal.
Thank you.
Next, 2014-324, 2031 through 33 West Baltimore Street, Austin Tate.
Yes, sir.
Afternoon, sir. We have this as an application to install 2 wall-mounted, single-faced, illuminated, including light-emitting diode ID signs onto a church, one facing West Baltimore Street and one facing South Pulaski Street. Is that correct?
That's correct.
All right. Mr. French for the planning department.
Thank you. The Department of Planning has no objection to the appeal, provided that the board requires that the approved signs meet and continue to meet these conditions, since they would be LED signs. That the entire face of each sign is approved for a light-emitting diode or LED screen. This must be installed in a single step, and that the LED sign adheres to the operational limits or other conditions that may be imposed by the board. That the performance of the LED sign conform to all the requirements of sections 11-205 and 11-305 of the zoning code by having a minimum dwell or uninterrupted display of message or image time of 10 seconds, that it will not increase the area of any existing sign, that it will not increase the degree of illumination, and it will not have any flashing, blinking, fluctuating, or otherwise animated light, that the LED screen will not have animations, movie clips, or other sound elements, that the LED sign will default entirely to black in the event of failure of its remote control system or an interruption of its copy, text, images, or both, and that the digital sign will have an automatic brightness control so that the sign will not constitute a hazard to passing motorists at night or during inclement weather. Thank you.
Thank you. And Mr. Tate, are you amenable to those conditions stated by the planning department?
Yes, sir.
All right. Anything further you'd like to add at this time?
Not at this time.
Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Thank you.
Thank you. Good luck.
Thank you.
Next, 2014-325, 6420 through 6506 Park Heights Avenue, James and Toya Cusack. Afternoon. Good afternoon. We have this as application to use the portion known as 6420 Park Heights Avenue for a beauty shop and barber shop. Is that correct?
Yes, sir.
Okay. Mr. French, anything for the planning department?
The planning department has no objection to this application. Thank you.
All right. And Mr. and Mrs. Cusack, anything further you'd like to add at this time?
No.
Okay. Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal. Thank you. And last but not least, 2014-333, 312 South Robinson Street, Chris Dotson.
My name is James Carroll, standing in for Chris.
Okay, Mr. Carroll, we have this as an application to construct a second-floor rear addition and second-floor rear deck with stair access onto a new rooftop deck. Is that correct?
Correct.
Okay. And Mr. French, anything for the planning department?
Planning department has no comment on this application. Thank you.
Okay. And Mr. Carroll, anything further at this time?
No, sir.
Okay. Zoning board staff, having previously reviewed the application, we determined that there is sufficient information to approve your appeal.
Thank you very much.
Thank you. All right.
I'm going to grab
Pardon. 30-second water break. Okay, next. Oh, thanks. Next, we're going to be dealing with a group of cases which includes cases where opposition is signed in. And frequently we found that opposition is the result of either a lack of communication or miscommunication between the parties, and it can be useful to offer the parties an opportunity to meet, discuss what their differences are, for the applicant to discuss with their opposition what the plans are, answer any questions, and try to see if a resolution can be reached between the two sides. Obviously, if two sides approach the board on different sides of an issue and ask the board for a resolution, someone is bound to go away from that encounter dissatisfied. And this is your opportunity to avoid that unhappy fate. Now, we'll call off the cases where opposition is signed in. At this point, we just want you to stand. We'll ask if, that is, stand where you are. And we'll offer you an opportunity to meet and confer with one another, see if you can get something worked out. You're certainly not obligated to take that offer, but we certainly do encourage and appreciate it. Cases where we have opposition signed in are 2014-305, 1800 and 1818 South Hanover Street, AB Associates, care of Nate Prettle. All right, great. They're already ahead of the game. Next, 2014-327, 901 Gorsuch Lane, Tyrone Staten. Okay, and who signed in on that? Okay, and have you folks met, tried to talk it out, see if you can get something resolved?
We did have a community meeting where he came and presented his information, and individuals within the community shared their concerns,
Okay, any hope of resolution? Okay, have a seat and we'll call you in turn. 2014-330, 5 and 7 South Carrollton Avenue, Jaron McCray. Okay, have you folks spoken before? Okay, would you care to speak, try to see if you can get a resolution worked out? Okay, just let us know when you're ready to go forward. All right. First case of the day is 2014-301, 1725 East Lombard Street, East Junker. Afternoon, Ms. Junker. We have this as an application to use the entire first floor as a restaurant with outdoor table service as accessory to the restaurant use, and use the second and third floors to house 2 dwelling units as a mixed-use, multiple-family attached dwelling. Is that correct?
That is correct.
Okay. Will all those giving testimony raise your hands and be sworn, please?
Raise your right hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Do we have staff reports?
Yes. First, we have 2 letters addressing different issues, but I'll take that. From Upper Phillipston Community Association, they write that they are basically in favor of the outdoor table service with 3 provisions, that no alcohol be served outside without the purchase of food. All outside table service will end at 10 p.m. in accordance with the Baltimore City noise ordinance. And 3, tables will be on the Lombard Street side and Register Street side of the building. Then they also add in their second letter that they are against the conversion or the continuation of the 2 dwelling units on the upper floor. And this is a letter from a resident at in support of the 2 dwelling units, and we have planning's report.
Thank you. The Planning Department noted that this property is currently authorized for use as a tavern and a single-family attached dwelling. The tavern is a non-conforming use, and this being a residence district, the change of non-conforming use from a tavern to a restaurant would be approvable by the board under the terms of the zoning code. However, the accessory outdoor table service is something which is not authorized in a residential district, and therefore the department is going to recommend disapproval. Thirdly, the conversion of a single-family dwelling unit to a multiple-family dwelling unit in an R8 zoning district, which this application proposes, is something which the zoning code requires be approved by ordinance of the mayor and city council. The Department of Planning therefore recommends disapproval of the portions of this appeal relating to accessory outdoor table service for the reasons I mentioned, and likewise disapproval of conversion of the residential portion of the premises from a single-family dwelling unit to a 2-family dwelling unit, because the zoning code requires that such a conversion be approved by a conditional use ordinance. The department has no objection to approval of changing the non-conforming use of the first floor of the premises from a tavern to a restaurant, provided that the applicant provides off-street parking to serve the restaurant according to the requirements of the zoning code, or that the board determines that there is a practical difficulty involved in providing the required amount of off-street parking for a restaurant. Thank you.
Thank you. Okay, Ms. Junker,
I'd like to tackle this one by one.
let's do that.
Okay. First of all, the tavern in its existing condition, just by history and by definition, is actually not even permitted in a B1. It's only permitted in a B2, so therefore not even allowed to be existing in the R8 at all, in any condition, but it's been grandfathered. So what we're proposing is a restaurant, which is, by design, permitted as a B1 alternative to the existing non-conforming permittance in the R8 district. So we're technically downgrading the degree of nonconformity by our proposed request, which, excuse me, gives you the legal authority to grant the outdoor accessory use. So that is that issue, okay? Because outdoor accessory use is permitted with the B1 use of the restaurant, which is a permitted alternative in the residential district. So I'm tying all these pieces together. So that's where I'm going in terms of the board having A, the legal authority to grant that approval, and then tying into that whole practical difficulty, but I like to use it as a Hail Mary, not as a nice start off. Therefore, so that's that initial issue with the restaurant, the outdoor accessory use, okay? Now with the parking is tied to the fact that if we were coming in here with a new proposed restaurant use, we would be required to provide this off-street parking resource. However, the operations as the tavern exists today is actually operated as a restaurant because they're providing food. So the difference between a tavern and a restaurant has to do with the degree of your receipts, the percentages of your receipts. And they're not operating predominantly as a tavern. They're actually operating predominantly as a restaurant. Therefore, and also what I can't find is any parking calculations for the tavern in the code. So regardless of the parking requirement, it wouldn't be 9. There would be a certain amount of parking that would be grandfathered in. I just can't provide you that number, unfortunately. Okay, that'd be great.
0.
So, going to that point though, regardless of what the number is, we're already operating in the condition that we want to be operating in. Therefore, we're not increasing any capacity of use for the condition. We're bringing the degree of non-conformity down to a degree of conformity. So if anyone were to come to you in the future for any proposed use, they wouldn't be able to use their tavern as their baseline. They would be coming to a lesser degree of non-conforming starting point of the restaurant use with the outdoor seating, which is only conditional board approval and tied specifically to this purpose to this owner, okay? And therefore, our parking increase requirement wouldn't impose an impact or hardship on the community because nothing's changing at all. In fact, we're actually reducing the proposed usage in the space by definition and by code. So that's my first issue, okay? Does anyone have any questions? Because I'm very linear right now in my thought processes.
Mr. Chair, I think you have some more. We've had this issue come up in the past. The restaurant request on Cross Street comes to mind. The zoning code 1971 treated taverns the same as restaurants. They weren't separated in the parking chapter. The tavern could serve food, a restaurant could serve alcohol. There was no threshold as to whether it has to be 51% food versus sale of alcohol. It was just treated pretty much the same. We've always applied the parking regulations since 1971 to taverns as the same as we have treated them as if it was a restaurant. So their parking is grandfathered in. There's no additional floor area requested, which would trigger any additional parking requirements. So I believe that planning's recommendation is contrary to the way we've always treated these uses. And again, a restaurant is listed as a conditional use in the B1, so it falls under the category that allows the board to grant uses that are listed as permitted in B1 district. And we treat the outdoor table service as a conditional use accessory to the restaurant, even though it's in a residentially zoned district, because the restaurant is listed as a conditional use in the B1. The changing of the use from under today's code, since the definitions of taverns and restaurants have now been separated, the changing of the use to a restaurant would not allow them to go back to a tavern. So just point that out to the board for your own information.
Therefore, my point being a downgrade in terms of non-conforming class. And I'll talk to you in
The question about the dwellings,
I'm not there yet.
We haven't gotten there yet.
oh, sorry, I'm getting ahead of the game.
So try to hold that thought unless I don't want to hear it. That being said, my next point comes to whether the board has the legal authority to grant what is considered a conversion. And we're not here before you asking for a conversion, because historically, 1725 was the tavern, and it was the dwelling unit, okay? And then it was consolidated with 1727, which was a dwelling unit. And so when the consolidation took place, the first floor of 1725-27 became a tavern. And basically, they closed up the rest of the space above the building. 1725 was still recognized as one dwelling unit, but all other space within the building has been vacant since then. And there is a provision in the zoning code, 3-305, that says, for purposes of this subsection, an empty building, yes, I understand that the building itself is not empty, but the area that we are calling out for this proposed use has been vacant, and therefore it is a portion of the empty building, and no other use has ever been in that space. It's considered to be a single-family dwelling unless it was last lawfully used in compliance with the normal bulk regulations within that district. And that vacant space was last lawfully used as a single-family dwelling, and the building has been vacant, and we're just asking for that single-family zoning status to be reinstated. It is not being converted from or to. And furthermore, if you go back to, it's not being altered. We're asking for basically the doors that have allowed no access to that space to be removed, and that space therefore to allow to be reinstated as its formerly used dwelling unit. We're not asking for increased density. We're not asking for additional occupancy. We are asking for the space that has always been allocated for its dwelling unit to now be allocated as its existing dwelling unit.
Have the properties been consolidated?
They are legally consolidated. And I have the zoning summaries that show, the records show that 1725 was the one dwelling unit and the tavern, and that 1727 was historically a single dwelling. And when they consolidated them, the area was closed off as the dwelling, and the area has been the tavern on the first floor only. Nothing else has ever occupied the space that was allocated for the dwelling. And therefore, we're not asking for a conversion.
Mr. Tanner, you had some thought on that as well?
Well, I'm not sure I agree exactly with Ms. Junker's explanation of it, but it's pretty much online. The properties were consolidated, I think, in 1997. And the way we applied the historical records is that at that time, the second floor of 1725 was a dwelling unit, and the second floor of 1721, I guess it is, 27, was also a dwelling unit. So there were two dwelling units in existence when they consolidated the lots. Whether or not those dwellings have been vacant or unoccupied is unclear. We have, in one letter from a community resident, they indicated that the dwellings were being used when it was a tavern, but not for moral purposes. That there was some unauthorized activity on the second floor. They indicate, this person, Blair Freed, who resides in the neighborhood, argues that they would much prefer to see the dwellings go back to their original use as separate rental properties for residential use. And it would work out to actually reduce the density that the property was being used for, because they had up to 5 bedrooms in that space that was during this whole time period.
Which was not under current ownership. I can't.
No, I
speak to
understand.
that. Right, but I just want to make sure the boards understand that.
And they support the new owner and his efforts to be compatible with the surrounding neighborhood.
Also, zoning I'm sorry.
And it's true, it's never been an empty building, so it really doesn't meet the requirements of the conversion requirements that say that it reverts back to a single-family dwelling for purposes of zoning. The fact is that the first floor has always been occupied. So that's my interpretation of how we configured the history of the property.
Okay. Any questions? Anything further?
No,
Thank you.
thank you very much.
We need a few more minutes.
Okay.
to Talk about this issue.
Okay.
Thank you.
Next case, 2014-318, 3201 through 3205 Noble Street. Afternoon. Are you Mr. Chestnut?
Yes.
Okay. Mr. Chestnut, we have this as an application to use the first floor portion known as 3201 Noble Street as a tattoo parlor and piercing services with sales of clothing, jewelry, and artwork. Is that correct?
Correct.
All right. If you can raise your hand and swear, please.
You swear or affirm the testimony that you're about to give in this hearing, the truth, the whole truth, and nothing but the truth?
Yes.
Do we have staff reports?
We have one report from planning.
Planning Department has no objection to this application. Thank you.
Okay. Mr. Chestnut, in looking at this, I think our conclusion was a little bit different than planning. We had some concerns as to whether or not the tattoo and piercing could be permitted.
Excuse me for interrupting. I think I gave the board the wrong impression when we talked about this. I said it was a non-conforming situation, but in fact, it's in a B3 district. Tattoo parlors are conditional uses. So I apologize for giving you some bad information.
In that case, strike what I was going to say. I was going to say that we're looking at this as possibly an accessory use, but
Yeah, it doesn't need to be.
why don't you tell us a little bit more about what you've got planned here?
Pretty much the location is zoned correctly. We plan on doing custom tattoos and piercings. Also to help out in the neighborhood, we was going to provide like the kids art classes and stuff like that.
Okay. Pretty large location.
Correct. There's a gym upstairs.
So it's just on the
First floor?
first floor? And is it the entire first floor?
Yes, sir.
Here we go. Here's a floor plan. Okay. And how do you handle disposal of the needles and equipment and that kind of stuff?
We have biohazard boxes.
Okay. And how often does that get picked up?
Honestly, it takes them like a long time to get full.
Okay. But it's a secure
Yes.
bin? All right. Okay. Anything further? All right. Thank you very much.
Thank you.
Mr. Barry?
Hanover Street?
Yes.
Just, we're going to make this very brief.
Okay. Let's call it officially. 2014-305, 1800 and 1818 South Hanover Street. AB Associates, care of Nate Prettle. Or Albert.
Do you wanna- I can just start by saying that the developer and myself met with many of the neighbors and neighborhood association. There's a letter of support from the neighborhood association. The opposition that was represented by Mr. O is something that was a surprise, and based on that, we want to meet with them in the next 2 weeks. If we could certainly get some assurance that we could be on the agenda in 2 weeks, if that's not a problem for the board, we believe we can bring back the neighborhood association and who she's representing, and hopefully have a consensus. Many of the things, I don't want to speak for her, many of the things appear to be questions about the plans and so forth, and that's fine. So,
Okay. Mr. Chair?
I think to be able to get the, it's feasible, if it's a highly contested case, we may have to consider the time frame for the case, but the planning had a recommendation that we need to probably work with also.
you know, speaking to the planning recommendation, which we were aware of, we were prepared today to offer a sort of a full explanation and a defense of why their position has some practical difficulties from an engineering standpoint. And so they're looking at it from a design standpoint. Our engineer, who's out in the hallway, is looking at it from what meets the city's utility requirements, stormwater management, everything else. So we had one discussion with planning. So I'm more concerned, frankly, about making the immediate neighbors happy at the moment. Any approval that we ask for is going to be required subdivision approval by the planning commission at a later point anyway. And certainly between now and then, we would work that out with them once we got through this process, if we get through this process.
Okay. So 2014-305, 1800 and 1818 South Hanover Street is postponed to, what's the next one? 21st?
5 o'clock on the 23rd.
Okay.
Yeah, it's a 5 o'clock docket on the
3 to
21st.
5 March is going to be one of the.
One of the, okay.
Yeah.
Okay.
All right.
Thank you very
Thank
much.
both very much.
I want the big one, right?
Okay, moving right along. 2014-322, 331 East North Avenue, Felix Ogala.
Good afternoon, gentlemen.
Afternoon, Mr. Ogala.
Yes, sir.
Okay, you can step a little closer. I promise we don't bite. Mr. Gallo, we have this as an application to use the entire premises as office space. Is that correct?
Yes, sir.
Okay, if you can raise your hand, be sworn, please, sir.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Do we have staff reports regarding this property?
Yes, first we have a letter from the New Green Northwest Community Association. They're going to discuss the problematic issues with the property in the past, and they fully support this new request to use the property as offices. And we have planning support.
Thank you. Planning Department notes this property is in a residential zone, R8. The applicant is proposing to use the property for offices. And even though the Planning Department has recommended under the Transform Baltimore new zoning code or replacement zoning code that this property in fact be part of an area rezoned to OR1, the fact is currently it is an R8 district, and allowing offices in this property would create a new non-conforming use. The Department of Planning therefore recommends disapproval of this appeal because the zoning code does not authorize creation of new non-conforming uses, which offices would be in the R8 zoning district containing this property. Thank you.
Thank you. Okay, Mr. Gala, I suspect that what Mr. French just said isn't something that's a surprise to you, is that correct?
Not at all.
Okay. And the position that we're in is that the board is a board of limited authority, and we can only do what is permitted under the code. One of the things we can't do is create non-conforming uses where those uses aren't permitted under the code, and you've got a proposed office use here in a district where we're not allowed to create office uses. So there we are. It kind of gets no more simple than that.
If I may say something, sir.
Yes, please.
The building in question, the block comprises 3 units. The VFW and the restaurant and my building. So the other 2 units comprises, my unit is 331, the second unit is 333, and the third unit is 335. Both 333 and 335 currently is zone commercial, used as commercial. The same building plan, the same identical building, the same structure inside comparable to mine. So there's no difference. My appeal to these bodies, already we have 3 units in the block and the other 2 units are used as commercial. I'm begging you all to accept my 2 to be used as. I cannot retain anybody to rent the property. That is my problem. Hence, I decide to move in there myself. My moving in will not create any additional impact more than what it is now. I'm a small business. I have only just one, myself and my assistant, that uses the building, that will be using the building. So I'm asking you all to reconsider, if there is anything you all can do for me.
Okay.
The other 2 properties that are being referred to are most likely existing legally established alcoholic use, but they're on separate lots.
And what he's saying there is that the use has been going on for long enough. It may be a use that's grandfathered in, and so therefore it was previously allowed for the current version of the zoning code, and then to the extent that those uses were already previously established, those uses are allowed to continue. But where those uses stop being in existence, or where they're not in existence as of the enactment of the code, then then the proposed use at that location becomes a non-conforming use. And it can result in sort of anomalous results such as this, where we may be faced with an otherwise meritorious plan, but one that we're still without the power to acknowledge under the code. Is this a location? Would it be possible here, David, to get an ordinance to approve this, or?
Possibly. As Mr. French described, the new zoning ordinance proposes a rezoning of that entire block. The council could introduce the bill separately, but it's not something easily accomplished.
I think that's your road to hoe at that point. Have you tried to reach out to the councilperson in this district at all?
No.
No. Is it Councilman Stokes?
We need a map, I don't know. Stokes or Branch, it's one of the two.
Okay. All right, anything further? Actually, would you like to postpone your case at this point?
Absolutely.
Or, okay,
Yes, sir.
why don't we do that? All right, 2014-322 is being postponed.
Thank you, sir.
All right, thank you. Next case, 2014-326, 24 East Madison Street. Okay, calling again, 2014-326, 24 East Madison Street. CK Enterprises LLC, care of Keith Gentile. Okay. 2014-327, 901 Gorsuch Avenue, Tyrone Staten. No, they're right there. Come on down. Unfortunately, we don't have any big wheels you can spin here.
Good afternoon, everybody.
Afternoon.
At this particular time,
Sorry. You're Mr. Staten?
yes,
Okay, Mr. Staten, we have this as application to use the premises as a dental laboratory, is that correct?
yes, sir.
Okay. And, well, why don't you raise your hands and be sworn, and then we'll go from there.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Mr. Staten, before I interrupt you, you were going to say something?
Yes, I would like to withdraw my application for use of a dental laboratory.
Okay. All right. 2014-327, 901 Gorsuch Avenue is withdrawn.
Thank you.
Thank you. Next, 2014-330, 5 and 7 Carrollton Avenue, Jaron McCray. Good afternoon, folks. All right, Mr. McCray, we have this as an application to consolidate the properties known as 5 South Carrollton Avenue and 7 South Carrollton Avenue. Use the premises as 2 dwelling units with first floor commercial and construct a 2-story rear addition as a mixed-use, multiple-family attached dwelling. Is that correct?
Yes, sir.
Okay. If you both can raise your hands and be sworn, please. Okay.
Raise your hands. Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And folks, you had an opportunity to talk before the hearing. Any progress towards a resolution?
Yes, the problem was that he had not met with the community association, so we had no idea what, and the application just said dwelling units, didn't say how many bedrooms, didn't say anything. We also had some issues with the property earlier when they had started work with no permits. We had to get a stop work order, and then we saw beams.
Do you have a resolution today?
I think that we only have one question. I think we're in agreement. The only question that...
You're shaking your head.
I think we're in agreement. The only question was if there's any off-street parking that would be required in the consolidation, because as two properties, then and 2 dwelling units, there wouldn't be any off-street parking.
It's 2 two-bedroom apartments, so the issue is there any off-street parking requirements since it's in the change?
Okay. And Mr. McCray, is that consistent with your understanding of where you guys are as far as getting to a resolution?
Yeah.
Okay, great. Do we have staff reports?
We have one report from planning.
Thank you. Planning Department notes that this property is located in the Union Square Historic District, and therefore, any and all alterations to the exterior of the structure on the property, additions, demolitions, new construction, require a notice to proceed from the Commission for Historical and Architectural Preservation. So with that in mind, basically the enforcement of any changes to the exterior of the property is going to fall within the hands of zoning enforcement under the Historic Preservation Ordinance. We also note that if the property is consolidated, this being a B2 zone, the property would require 1 parking space off-street per 2 dwelling units. With the consolidation of the property and creation of 2 dwelling units, they would therefore be required to have 1 parking space, and the applicant would need a variance of 75% of the parking requirement in order not to have to provide a parking space on site. The proposal apparently is to use nearly all of the lot area for the addition, or I should say the remaining free lot area for the addition. Therefore, it's unlikely that there would be a parking space created, and even if there was, the property is bordered by alleys that do not meet the zoning code requirements for access. That said, the Department of Planning has no objection to the appeal. If the board decides to approve the application, the department requests that approval be conditional upon the applicant obtaining a notice to proceed from the Commission for Historical and Architectural Preservation for all exterior work that would be performed as a result of such approval. Thank you.
Okay. All right. Mr. McCray, do you understand the conditions stated by the planning department? Okay. And those are acceptable to you? Okay. One thing, in looking at the drawing here, on your site plan, it looks like in the rear, you've got included 5 parking spaces and what you've got designated here as a metered parking lot. Is that part of?
No, parking lot is not part of the.
Okay, all right.
It's a, yes.
One at a time, folks. Okay, all right, so you weren't including that as part of your property?
I think
yes or no?
Yes, sir.
But you don't own it, or you don't control it, you don't lease it?
No, we don't control it.
Okay, all right, good. All right, and ma'am, can you state your name again, please?
Jane Buchari.
Okay, and Ms. Buchari, you said that your concern was about parking, and I think as acknowledged by the planning department, the property is bounded by alleys that don't permit or don't legally qualify as access points for in order to get to the back, in order to access a parking lot. So it looks like there can't be parking offered here, in addition to the fact that the addition is shown to cover pretty much all of the lot. So it's not going to be practically possible to offer parking.
And actually, again, most of the problems was because we had no information whatsoever.
Yes, I understand.
I don't actually think that's a problem, because again, the building is actually 2 buildings.
Mm-hmm.
And so there is enough parking in the front for at least 2 cars,
Okay.
on the street.
Mm-hmm.
It was a matter of.
It was a requirement based on the zoning.
Okay. And Mr. McCray, did you have anything further as of right now? Okay. Any questions? All right. Thank you, folks, for taking the time. Take care. Yes, you're excused.
I'm just always nosy. But
All right. Next up, 2014-334, 3816 Bell Avenue. Okay. Okay. Gotcha. All right. Courtney Charles?
Yes, sir.
All right, Mr. Charles, we have this as an application to house 4 dwelling units premises. Is that correct?
Yes, it is.
Okay. Can you raise your hand and be sworn, please?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Do we have staff reports?
We have one report from planning.
Thank you. Planning Department notes that this building has been used in the past as a multiple-family dwelling. Its conversion, if it was a single-family dwelling, would not be allowed by the zoning code. Therefore, it's basically incumbent upon the applicant to demonstrate to the board that this property still has the status of a multiple-family dwelling. That said, the Department of Planning has no objection to this appeal, provided that use of the premises as 4 dwelling units has not previously been discontinued or abandoned. Thank you.
Thank you. And Mr. French, can I take your remarks to be referring to the vacant house notice issued in February this year?
That is correct. We actually noted that the property had gone into some type of foreclosure action because the property was acquired from a bank, which obtained it, of course, through some legal process from the previous owner before this. Thank you.
Gotcha. Okay, Mr. Charles. Why don't you tell us about what you're proposing here? Also, if you can, well, when did you acquire the property?
Approximately 6 months ago.
Okay. March?
Yes.
Could be a little earlier, maybe like February.
Okay, so you acquired it in February. All right, and from whom did you acquire it?
I purchased it from, I think it was a bank.
Okay. And I think that Mr. French had mentioned that there had been some kind of foreclosure, I guess, on the property. Do you have any
No, I have no
information
knowledge.
as to when?
I did it through the computer, on the computer. I bid on it, and I was the highest bidder, and it was granted to me.
Okay. And do you know when the bank had foreclosed on the prior owner?
No.
No? Okay. All right. And what do you have planned here?
Well, I bought it, and it was in bad condition, and I'm just restoring it back to as it was.
Okay, now our information shows it was last used as, I guess, 3 dwelling units with 2 rooming units. And you're proposing, I guess, getting rid of the 2 rooming units and making and creating an additional dwelling unit. Okay.
Well, on record, that's what it shows. In reality, it's 4 apartments. I'm not doing no tearing down no walls, putting in no doors. It has 4 bathrooms, 4 kitchens, and each floor has a bedroom, bathroom, you know.
Okay. All right.
Combining the 2 rooming units into 1 dwelling unit eliminates, right now they're grandfathered in, up to 5 parking spaces. Each rooming unit requires 1, and each dwelling unit requires 1. If you consolidate the rooming units into 1 dwelling, it reduces the parking to 4. So it would not require variance for parking. However, he does need a variance for the lot size because the rooming units were never calculated into the density requirements. They kind of evolved over the years under the definition of family in the code that allows up to 2 roomers. So, I guess that's all I wanted to have pointed out to the board, so you can use that to make your decision.
Yes.
You keep mentioning rooming units. Where were the units? On what floor?
Yeah, it's your property, sir. I don't know.
Well, like I said, I know.
If I can clarify this.
There's the first floor, second floor,
Sir,
so,
I'll answer that question.
okay.
On paper,
Mm-hmm.
this property is identified as having 3 dwelling units and 2 rooming units.
Yes.
It sounds like in reality, what had happened was that the rooming units were never created. In reality, it was always operated as 4 dwelling units. One thing that you may not be aware of is that there were three prior appeals. First one in 61, next one in 70, and one after that was in 74, to try to legally create the 4 dwelling units.
Yes.
Those were all disapproved.
Yes.
It sounds like one of those owners, undeterred by the lack of success in the appeal, decided to just build the 4th dwelling unit and keep it on paper as rooming units. So the rooming units, you don't need to be concerned with as of right
Okay.
now. I guess something that is more consequential is that the lot size requirement requires a variance in order to have the 4 dwelling units.
Yes.
Here you'd need a 14% variance.
Excuse me, can I say something?
Please.
I was told that with the size of the house, you're required to have 8,750 square feet.
Mm-hmm.
And with the new law, you can have a reduction of 25%, which brings it down to 7,525 square feet.
That's what the board's approving.
Yes.
That's why you're here.
Yes, that's the variance that I was just talking about.
Okay.
All right, I think I know all I need to know. So the work that you're doing, you're not changing the walls or anything like
No,
that? You're
just
basically
cosmetic.
just fixing up what's there?
The house seemed like it was abandoned for quite a while. It had approximately 4 holes on the roof that goes all the way down to the basement, damaging the walls and the flooring. So we're taking up the floors, putting down new floor where it's damaged, changing the walls where it's wet, and putting new sheet rocks.
Okay.
And fixing the ceiling.
All right. Any other questions? All right, thank you.
Thank you.
All right. Calling 2014-335, 2453 Maryland Avenue. Matthew Day for M&T Driving School. Calling again, 2014-335, 2453 Maryland Avenue. Matthew Day for M&T Driving School. All right. Is that it?
I think I'd recommended a deferral. Perhaps they took them literally.
Yeah, I was going to say, since we have that down, if we can clarify that. That might have been a bit of a miscommunication. All right, and we are off the record. Wow, that was
Like you'll make your
lightning.
Scheduled meeting.
Yeah, we did that in less than an hour. We did that in 50 minutes. Nice.
It's like college, thank God for C's.
All right. Which ones do we want to talk about?
Let's see. Was 316 the consent? I can't remember. Yeah, okay.
Yes.
The only one I had was Bell Avenue. And there was no showing of hardship. No showing of any of the criteria. But I'm sort of okay with it.
You know, that one,
Yeah.
I think that we're always in the same mind of these, well, frequently. Yeah, I think that, well, I start off with the position that this is it's a foreclosure. And, you know, it's likely only here because there was a foreclosure and it sat there and basically deteriorated. So these create sort of special circumstances in and of themselves. It, irrespective of the prior appeals, it was being operated that way, and he purchased it that way. The city has to get these things back onto the rolls. So, because of those circumstances, I wasn't as concerned about the variance issue.
Yeah, that's right.
But any others? Anybody else have any thoughts about Bell Avenue?
I'm kind of with you. It's just, what's the alternative? It's going to stay vacant.
Yeah. All right. Going once, going twice. I guess everybody wants to get out of here by 3. All right, let's start. 2014-297, 208. Oh, can I grab my phone there, Bryce, before you back up? Thank you. Thanks. 208 South Pulaski Street, Verizon Wireless, care of Jack Andrews. This case was consent with planning department conditions, together with 2014-317, 55 Marketplace, which is also Verizon Wireless, care of Jack Andrews. 2014-165, 3050 Liberty Heights Avenue was postponed. 2014-2020, 1118 through 20 South Charles Street, and that one together with 2014-316, which is also 1118 through 20 South Charles Street, both by consent with conditions stated by the planning department. 2014-247, 1000 through 1012 South Charles Street, Verizon Wireless, care of Julie McIntosh. That was consent with conditions stated by the planning department for cell phone towers, together with 2014-331, 1713 East Pratt Street. 2014-298, 113 Witherspoon Road, that was by consent. 2014-299, 3600 Elm Street was by consent with conditions stated by the planning department for outdoor table service. 2014-300, 6201 Seaforth Street, Nathaniel Green. That case was by consent with 2014-321, 3308, and 3310 Ridgewood Road. Next was 2014-301, 1725 East Lombard Street. I was a yes.
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 2014-302, 4314 Springdale Avenue was by consent. 2014-304, 3501 Brems Lane was by consent. 2014-305, 1800 and 1818 South Hanover Street was postponed. 2014-307, 101 through 15 West 25th Street was postponed. 2014-308, 223 through 25 Park Avenue was postponed. 2014-310, 1008 West Cross Street was by consent. 2014-312, 901 and 907 Holland Street was by consent with conditions stated by the planning department. 2014-315, 3607 Fleet Street and south side of Fleet Street, 100 feet east of South Conkling Street was by consent. And that was also as revised to merely expand the fourth floors as shown on the drawings submitted. One thing I had with that, David, that showed a sink in the drawings. I understood that there's not allowed to be plumbing facilities and living space.
Yes, that's basically, if without the sink and the smaller enclosure, it would be exempt from the height requirement. But by adding the sink in the additional floor area, it needed the board's approval. So basically, it's going to be an access room to the rooftop deck.
Mm-hmm.
And I think their earlier version also included a sink, but it was just in a smaller space.
Okay.
So it becomes part of the structure and not an exemption of the height requirement. So basically what we did was grant a variance to that effect.
Mm-hmm. All right. Next up, 2014-316, no, I already did that one. 2014-318, 3201 through 07 Noble Street. I was a yes.
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 2014. 2014-320, 3801 through 07 Pall Mall Road, was by consent. 2014-321, that already did that one. 2014-322, 331 East North Avenue was postponed. 2014-324, 2031 through 33 West Baltimore Street was by consent, the conditions stated by the Planning Department. 2014-325, 6420 through 6506 Park Heights Avenue was by consent. 2014-326, 24 East Madison Street was a no-show and be dismissed. 2014-237, 901 Gorsuch Avenue was withdrawn. 2014-330, 5 and 7 South Carrollton Avenue was, yes.
Yes.
To that.
Yes.
2014-331, 1713 East Pratt Street, I already did that one. 2014-332, 714 through 16 North Fremont Avenue was postponed. 2014-333, 312 South Robinson Street was by consent. 2014-334, 3816 Bell Avenue, I'm a yes.
Yes.
And 2014-335, 2453 Maryland Avenue was a no-show, but, well, I guess, yes. Find out what's going on with it.